Losing a loved one is an incredibly difficult experience. During such an emotional time, the last thing you want to navigate is a complex legal system. Yet, understanding family probate is an important step in honoring their legacy. If you are facing this process in Boston, Massachusetts, this guide will help clarify the purpose of the local probate court. Please note, this video is for informational purposes only and does not serve as legal advice. When a loved one passes away, you might frequently hear the term probate thrown around, especially here in Boston. But what exactly does it mean? Simply put, probate is the formal legal process of administering a deceased person's estate. Think of it as a necessary bridge between a person's passing and the final distribution of their belongings. The probate process serves 4 essential functions. First, it legally validates the deceased person's will. Second, it identifies and inventories all of their assets. Third, it ensures any outstanding debts and taxes are completely paid off. And finally, it oversees the fair distribution of the remaining assets to the rightful heirs or beneficiaries. You might wonder if you can avoid the probate process entirely. In Massachusetts, the answer is often yes. For instance, any property held in joint tenancy with rights of survivorship bypasses probate completely, transferring directly to the surviving owner. Another popular method is a living trust. Because the trust legally owns the assets, they do not go through the probate court when you pass away. Massachusetts also offers a simplified process called voluntary administration. If the total estate value is under $25,000, excluding real estate, you can skip formal probate. Finally, assets with named beneficiaries, like life insurance policies or retirement accounts, are paid directly to your loved ones, keeping them entirely out of the court system. For anyone navigating probate or family law in Boston, your primary local resource is the Suffolk County Probate and Family Court, located at 24 New Chardon Street, Boston, Massachusetts, 02114. This specific courthouse serves all Suffolk County residents. Before making the trip, always contact the court or verify details on their official website. Court hours and procedural requirements can occasionally change. By checking online first, you can find the current phone number, download essential forms, and ensure you are fully prepared for your visit. The Massachusetts probate process can be broken down into 9 key steps. It begins with filing the petition. You submit the official request and the original will, if one exists, to the Family Probate Court clerk. Next is the notice to heirs. Legally, you must notify all interested parties, heirs, and creditors about the probate proceeding. This is often done via certified mail or public notice. Step 3 is the appointment of the personal representative. A judge formally grants authority to the executor, empowering them to act on behalf of the estate. Step 4 is bonding. The court may require the representative to secure a probate bond, which acts as an insurance policy protecting the estate from mismanagement. Fifth is inventory and appraisal. The representative must identify, catalog, and determine the exact fair market value of all estate assets, from real estate to bank accounts. Step 6 involves the payment of debts and taxes. Before any heirs receive their inheritance, valid creditor claims, outstanding bills, and any required taxes must be settled. 7th is the accounting. A detailed financial ledger tracking all money coming in and going out of the estate must be prepared and presented for approval. Step 8 brings the distribution of assets. The remaining property and funds are legally transferred to the rightful heirs or beneficiaries, exactly as outlined in the will or state law. The 9th and final step is closing the estate. Once everything is distributed, the court issues a final decree, officially closing the probate case and releasing the representative from their duties. How long does probate take in Boston? It is one of the most common questions families ask. A straightforward estate usually wraps up in 6 to 12 months, while complex estates with disputes can take significantly longer. The process follows strict Massachusetts milestones. After filing the initial petition and notifying all parties, the personal representative has 3 months to file a complete inventory and appraisal of the estate. Additionally, creditors have exactly 1 year from the date of death to file claims. Once all debts are settled and the court approves the final accounts, the estate officially closes. Navigating probate in Boston comes with specific costs. First are court filing fees. In Massachusetts, these typically run several $100s, but you should always check the official Massachusetts court website for current fee schedules. Beyond filing, you must account for personal representative fees, which legally allow reasonable compensation for managing the estate. You will also have attorney fees, billed either hourly or as a percentage. Additionally, factor in appraisal fees for property and bonding costs if the court requires a surety bond. Understanding how these expenses break down is crucial. Attorney and representative fees usually form the largest share, while filing and bonding costs are smaller. Planning for these categories ensures a much smoother probate process. What happens if you pass away without a valid will? This is legally known as dying intestate. When this happens, Massachusetts law steps in to dictate how your assets are distributed. The state prioritizes your surviving spouse and children first, before moving to parents or more distant relatives. Because you didn't leave instructions, the probate court will also appoint an administrator to handle your estate, which means a judge decides who manages your legacy, not you. Navigating the Massachusetts probate process on your own can feel like trying to untangle a massive, complicated knot. It is often complex, deeply time-consuming, and emotionally draining for grieving families. This is precisely where a qualified Boston probate attorney steps in to help. They provide expert advice on local laws, meticulously prepare and file court documents, represent your family in hearings, and negotiate to resolve tense disputes before they escalate. While attorney fees are a financial investment, the resulting peace of mind, expedited process, and ultimate protection of your family's legacy are truly invaluable. Navigating probate court doesn't mean you have to do it alone. Boston offers several essential resources. The Suffolk County Probate and Family Court is your primary hub for filings. For representation, the Massachusetts Bar Association provides a great lawyer referral service. If you need reduced-cost legal help, organizations like Greater Boston Legal Services and the Massachusetts Legal Assistance Corporation offer crucial support. Finally, a common question. What is the difference between an executor and an administrator? An executor is named in a will, while an administrator is appointed by the court when someone passes away without one. Navigating the Family Probate Court in Boston can feel overwhelming, but understanding the process makes the journey manageable. Remember, you do not have to do this alone. Seeking professional legal guidance and consulting official court resources will provide essential clarity. For more comprehensive guides, supportive tools, and resources to help your family move forward, visit funeralus.com today. Thank you for watching our guide on the Family Probate Court in Boston. Understanding the probate process can save your family time and stress. If this was helpful, please hit the like button, subscribe to our channel, and leave your questions in the comments. See you next time.